Okay, hello everyone. Welcome to the Art Law Talk. Let me introduce my colleague, Judith Bressler, who's an attorney at the law firm and an art law specialist with Withers Worldwide. She's also a professor at New York Law School, specializing in art law, and she's co-author of this wonderful 2-volume treatise, which Forbes magazine has called the Bible of the industry, and she's married to Ralph Lerner and lives in New York City.
And good afternoon. I, in turn, will introduce my partner. This is Ralph Lerner. He is an art law specialist at Withers Bergman, and also known as Withers Worldwide. He is a member of ACTEC. He is co-author of this treatise, which the Wall Street Journal has called the standard text. And he's married to Judith Bressler, and he lives in New York City.
So,
well, here,
Judith,
yes.
Tell us a little bit about what we have to do when we're buying works of art here.
Well, here we all are, and we are absolutely at the biggest art fair here in the United States. And I am guessing that at least some of you are contemplating buying a work of art. I always advise our clients to do a little bit of due diligence first and to satisfy themselves by answering the 4 questions, which are up there. Number 1, is the art authentic? 2, is it in acceptable condition? 3, am I paying a reasonable price? And 4, am I getting good and clear title? So let's look at the first. Is it authentic? Well, one thing you can do is get as much information from the seller as to the ownership history, and you can verify the ownership history by engaging either an art appraiser or an art historian. You can also have the work authenticated by a recognized expert in the artist. You can check to see if the work is included or will be included in a catalog raisonné that's authored by a recognized expert on the artist. You might also want to check the publication and exhibition history of the art to see if other people have also deemed the artwork to be authentic. And finally, and on rare occasions, in the event that the authenticity might be a problematical issue, you could consider engaging the International Foundation of Art Research to conduct a scholarly investigation. Now, as to the second question, is it in acceptable condition? Here we go. Ordinarily, unless the work that you're buying is the very first sale of the work, you should get a title report, a condition report on the condition of the artwork. And ordinarily, you would get a condition report from the seller. However, if you are buying a work of art of significant value, you might consider engaging your own conservator in order to get an independent assessment of the artwork's condition. The next question, am I paying a reasonable price? And I think we're going to go backwards. There we go. Am I paying a reasonable price? You can engage the services of an art appraiser who will locate and actually correctly identify the artwork that you're buying and establish its proper value, perhaps by using comparable sales in the relevant marketplace. Alternatively, you could engage the services of an independent and knowledgeable art advisor, somebody who charges for her time rather than as a percentage of the transaction, to give you independent and conflict-free advice. The art advisor could also help you negotiate the sales price as to what you're purchasing and could give you some good advice on collection management. The final question that you should ask yourself, am I getting good and clear title? Again, I tell my clients, confirm the provenance. You also might want to check with the Art Loss Register to make sure that the work of art that you're buying hasn't been reported lost or stolen. If you know the name and address of the seller, you could also consider running a lien search and a judgment search in state and local registries. After all, you want to make sure that the artwork that you're buying hasn't been pledged by the seller as collateral to secure a loan that the seller's getting from a third party. You also want to make sure that the artwork you're buying from the seller, that the seller isn't going through a divorce and is perhaps selling you a work of art that he or she hasn't gotten permission from his soon-to-be former spouse. If the work of art is coming from abroad, you might want to make sure that the art is in compliance with all foreign law. Some works, particularly coming from France, coming from the UK, require an export license. And finally, when you find that there is a gap in provenance in the 1930s and the 1940s with respect to the art, you might want to consider getting art title insurance. Now, that's all my pictures. That is a fair amount of due diligence that is required when you're buying a work of art of any reasonable value. And it always astonishes me that when you buy a work of art and you drop 6 figures or 7 figures or even 8 figures for that matter, what do you get from a gallery? You get a single page invoice, a lot less paperwork than you get if you're buying a car. And what is on the invoice? Generally, a description of the artwork, that is, the name of the artwork, the name of the artist who created it, a description of the artwork's dimensions, the medium of the artwork, the date it was completed, and whether or not it was signed. So you have a full description of the artwork. You also have on the invoice the purchase price, also the sales tax, which you as the buyer are responsible for. Generally, you'll find on the invoice instructions for payment, usually by wire transfer, so you'll see some wiring instructions. And you'll also see who is responsible for paying the packing, shipping, and crating of the art. And finally, there'll be a notation on the invoice generally that says the title doesn't pass to you, the buyer, unless payment is received by the dealer in full. Now, I should add that if you are buying a work of art in New York State, a buyer is protected to some degree because under New York law, if an art dealer makes a statement with respect to the authorship of a work of art, so for example, puts on the invoice that a work is by Picasso, that amounts to an express warranty of attribution. But we at Withers never, ever let our clients buy a work of art based on a flimsy one-page invoice. What we do is we create a bill of sale that's signed both by our client, the buyer, and by the dealer, turning it into a written, signed contract. And what does this bill of sale include, aside from what I mentioned on the one-page invoice? Well, it provides that the art will be shipped by experienced art handlers. It provides who is going to insure the art while the art is in transit. Our bill of sale will require the dealer to make numerous representations and warranties with respect to the art, that the art is authentic, that it has, the buyer is going to be getting good and clear title, that the dealer has provided our client, the buyer, with all the information about the artwork that the dealer has, that to the best of the dealer's knowledge, the artwork has not been restored or repaired other than as set forth in the condition report which we require the dealer to provide for our client, and that if the work is coming from abroad, that it has been in compliance with all relevant foreign export laws. In addition, we require the dealer to back up the representations and warranties with an indemnity, and aside from providing the condition report, if it's not a first sale of the art, we also require the dealer to provide our client with an art loss register report to make sure that nobody has reported the artwork our client is buying as either lost or stolen. And finally, in addition to all of that, we require the dealer to provide our client, the buyer, with a complete listing of the provenance, that is, the ownership history, a complete listing of the exhibition history of the artwork, and a complete listing of all bibliographic references, that is, all the literature that either illustrates or mentions the artwork that our client is buying. These are part of the good records that a serious collector should have with respect to every work of art in his or her collection. Now, let me just say a word about warranties. The statute of limitations in every state in the United States, except Hawaii, for a breach of warranty of a sales contract is 4 years. That's not much time. So if you buy from a gallery, what the gallery represents and warrants, for example, is a work by Picasso, you only have 4 years to determine, if that work is not by Picasso, to sue the gallery. That's not a lot of time. So if you have any doubt whatsoever as to the attribution of a work of art that you're buying, I strongly suggest that you get an independent authentication of that artwork shortly after you buy it so that you can avail yourself of the recourse of suing for breach of warranty and getting recovery. Now, let's assume that you bought an authentic Picasso and you take it home and you hang it on your wall and it's hanging over the mantle over your fireplace and you're looking at it with great admiration, and it suddenly occurs to you that this image with your family gathered around it would make an absolutely fantastic holiday card. It'd be a great way to show off your most recent acquisition to your relatives, to your friends, and to those hordes of acquaintances that maybe don't rate an invitation to your home. So you gather your family around, you snap a picture of your family standing by the Picasso, you turn it into a greeting card, you make lots of copies of it, and you send it out to all and sundry. Send lots of these out. Only, you don't own the copyright to that image. So, it's a small world, the internet being what it is. So if any of the Picasso heirs would find out what you did, you could get a cease and desist letter if you're lucky, or you could get sued if you're not. How so? You bought the painting and you own the physical painting. But when you buy a work of art, you do not acquire at the same time the intangible rights that are embedded in that painting. For the example of the Picasso, you did not acquire the right to reproduce that image, either as a standalone or on anything else, like a holiday card. You did not acquire the right to commission somebody to create a sculpture based on your painting, or a mural or a wall hanging for your dining room. These intangible rights of copyright remain vested in the artist, or after the artist dies, in the artist's estate. And they can only be transferred by assigned writing, and they are virtually never transferred when you buy a work of art. So keep that in mind. Now, let's say that a number of years have passed and Picassos have more than maintained their value. They've gone up in price, and you need some cash, and you figure, this is a good time for me to sell my work of art. And you look at the image, and it's absolutely a fabulous image, one that would excite the buying public. So you figure, okay, I'm going to sell it at public auction. So you go to one of the large auction houses, you go to Sotheby's, you go to Christie's, maybe you go to Phillips. One of the big houses accepts your work on consignment, and they hand you a consignment contract to sign. Now, it's really interesting because otherwise sophisticated collectors who are selling works through an auction house think that that piece of paper is graven in stone and it can't be negotiated. Well, I'm here to tell you that if you engage a lawyer to negotiate that consignment contract, whatever you've paid the lawyer, you will make back many times over. What can be negotiated on this living, breathing document? Well, selling charges can be negotiated, marketing can be negotiated, and of course the legalese. So what kind of selling charges can be negotiated? Well, you can negotiate the packing, the shipping, the crating, the customs duties. You can make the auction house pay for all of that. Catalog illustrations, again, have the auction house pay for that. If there are any issues with respect to restoration or running some tests on the work or framing, again, let the auction house pay for that. On occasion, when the property is in the auction house's custody, you can even negotiate having the auction house insure it for its high pre-sale estimate rather than for the mean of the pre-sale estimates. There's ordinarily a service charge in the event the work doesn't sell. You can negotiate that away. And if the auction house really wants your work, you can even make the seller's commission go away, because the auction house will get a substantial fee on the back end by way of the buyer's premium. And even if you can't get a 0% seller's commission and you have to pay something to the auction house, you can water that down. In fact, you can even at times get an advance from the auction house against expected sales proceeds. All right, those are just some of the selling charges that can be negotiated. Now, what about marketing? Well, the standard auction agreement provides that the auction house has the sole discretion in terms of the time and the manner of the auction and the date and what auction it's going to put your property in. Well, surprise, surprise, you can negotiate certain things. For example, you can negotiate where in the auction your property is placed. There are a number of collectors who, for one reason or another, don't want their property to be placed at the back end of the auction. Maybe they think it's anticlimactic, maybe they think that people are going to walk out before the auction is finished, and of course they want as many people in the auction room as possible because they're all potential bidders. So you can ask for your property to be placed in the front half of the auction. If you are consigning more than one work at a time, under the consignment agreement, you could ask the auction house to create for you a single owner illustrated auction catalog of your property and have it offered at auction at any of the auctions where at least one lot of your property is being offered. You could also ask the auction house to create promotional literature based on what you're consigning to them and have it sent out ahead of time to targeted prospective bidders. You could even ask the auction house, if you've got some pieces of significant work, when they advertise the upcoming auction in an art periodical, to feature illustrations of the work that you're selling. If they're going to be doing a tour of highlights of upcoming things for sale, you could ask that one or more of the objects that you're consigning are going to be included in that tour. If it's appropriate, you could ask for a life-size reproduction of one or more of your works to be in the foreign offices of the auction house. If you are flying in for the auction because you're from out of town, you could ask the auction house to give you premium accommodations and premium airline tickets and pay for them so you can watch the auction. And you can ask for skybox seating. It's amazing what people have asked for, and when the auction houses really want the property, they will do it. I have to tell you just one funny quick story. My favorite concession that I've gotten from an auction house is I was representing a client who shall go nameless, who had to sell a work of art. He needed some cash. He was unfortunately madly in love with the image, and he really didn't want to have to sell it, but he had to sell it. So I was able to get the auction house to make a high quality reproduction of that work for my client, just to keep in his house, not to be released into the stream of commerce, but to keep in his house so he could enjoy the image, and then the work would sell and he'd realize the sales proceeds. So again, if you know who to ask, you can get a lot of concessions from these auction house agreements. And finally, you can, of course, negotiate some of the legalese. If you consign a work to the auction house, and then the auction house takes it, and they examine it, and they put it in a catalog, and then you decide, oh, you know what, I don't think I want to sell it, and you want to withdraw the work from the sale, you're going to have to pay some penalties. And that's fair, because the auction house went to a lot of time and expense to assure themselves that it's authentic and cataloging your work. But you can negotiate down the amount of penalties you'll have to pay. And you can also, to some extent, limit the auction house's discretion in terms of the conditions under which they might choose to withdraw your work from sale. And you can also negotiate clearly some of the host of representations and warranties that as a seller you're required to make to the auction house, and you can negotiate down to some extent the indemnifications that you're required to make.
You know, Judith, I have one quick question. You sell the work at auction, it sells, the auction house gives your client the money, and he goes out and maybe he buys a new house and a new car and pays whatever income taxes he has. Is he home free now from the auction house?
No, because the auction house retains, and this you can't make go away, nor should you. The auction house retains the right to rescind a sale if, in its sole judgment, you can negotiate that, it determines that proceeding with the sale will subject either it or you, the seller, to liability. So if you consign what you and the auction house thought was a Picasso, it turns out that it was not authenticated by the Picasso committee, and the buyer wants his money back and wants to return it to the auction house, if they're satisfied that it's not authentic, will rescind the sale, give the buyer back his or her sale proceeds, and then look to you, the seller, and it doesn't matter if you've already spent the money, tant pis, have to pay it back, and if you can't, then you better start practicing your dishwashing skills. You're on the hook.
I don't think I like that answer.
Too bad. Why don't you tell us something about tax?
Well, you know, with taxation, that's one thing we're not going to avoid. We're coming to the fiscal cliff here. You hear about it and read about it every day. So you're not going to avoid taxation. You should keep in mind that when you sell a work of art, the long-term capital gain rate is 28%, not 15% as it is for real estate, stocks, bonds, and other capital assets. So right away, you see the hostility towards the arts. What's the most pressing question right now is the ability for individuals to make gifts and take advantage of the 5,120,000 lifetime exclusion. That exclusion will expire on December 31st of this year, and everyone is afraid that it's going to disappear and it will go back to $1 million. So there's a great deal of excitement about people who are trying to make gifts to take advantage of the $5,120,000 exemption. But what they have to take into consideration is what is the value of what I'm giving. They don't want to give away cash because they have works of art, so they want to be able to give away a work of art. That's not, it's not the first slide. Okay, just leave it this way. So the IRS says the fair market value is the price that a willing buyer a hypothetical willing buyer would pay a hypothetical willing seller, neither being under any compulsion to buy or sell, and both having full knowledge of all the facts. And it must be in the most common marketplace. So where do you find the hypothetical willing buyer and the hypothetical willing seller? The IRS says the rule is the same whether it's for income tax, gift tax, or estate tax purposes. You know, I remember I was once giving a lecture before the Appraisers Association, and I was going to California, and they sent me a first-class ticket, which was a great treat for me. And I was about to take my seat when someone, and he was about my age, taps me on the shoulder, and he says, "I'm going to be your seat buddy. Let me introduce myself. I'm from the state of Tennessee, and my name is William Sellers, but my friends call me Will." And I turned to him and I said, "Oh my God, you're the hypothetical willing seller." The good part was he didn't talk to me for the rest of the trip. Where do you find this hypothetical willing buyer and willing seller? Let me give you an example. Young couple, both professionals, dating, concentrating on their careers. And you know what the dating scene is in New York City? On again, off again, on again, off again. And let's assume this couple has been dating for 9 years, the average dating period. Finally, they decide that they're going to complete this dating sequence by marriage. And it's still traditional to have a symbol of this forthcoming union with a ring. So they check their BlackBerries. They each have an hour free 2 Thursdays hence at 11 a.m. And they meet on the corner of 57th Street and 5th Avenue. If you've been there, you see the big Tiffany's building. And if you've been in Tiffany's on the first floor, the saleswomen there are amazingly thin. And they can talk without moving their lips. And as you're putting the ring on your fiance's finger, you hear $50,000, but you don't know where it's coming from. At that moment, if you're thinking, who's the willing buyer? Well, hopefully you are. And the willing seller is Tiffany's, and hopefully that is correct, that's for sure. Neither under any compulsion to buy or sell, and that's hopefully true. Both knowing the full facts, the value would be $50,000. Now, let's suppose they go back to their respective offices. The young woman meets her best friend for a late lunch. They have a couple of glasses of wine. They talk about the forthcoming union. Well, prepare yourself. This part is a little sad, so get ready here. So as she's crossing 3rd Avenue, she looks down to admire the diamond ring, and the setting sun flashes off the diamond, blinds her, and she doesn't see the taxi cab, and boom, it hits her and kills her. And you're appointed the executor of her estate. And now you have to value that diamond for estate tax purposes. If you go back to Tiffany's, they might write you a note on pale blue stationery. But are they going to give you back your $50,000? No. You might have to go to 47th Street, which would be the most common marketplace where that item is bought and sold. So in valuing your work of art, you have to identify the most common marketplace. Let's take another example. The closing days of World War II. United States Army is coming through northern Germany. They come to the medieval town of Quedlinburg. In Quedlinburg, there was an old church, and before the war started, the treasures were taken out and hidden in a cave. United States Army finds that cave and all those treasures, and a first lieutenant is told, guard those treasures. But in the confusion at the end of the war, nobody told him to stop. So he shipped them home to his mother in Texas. 60 years go by, and he dies. And a couple of the items were sold back to the church in Quinlanburg with an intermediary. Now, the IRS read the newspaper, and they take a look at his federal estate tax return, and they say, gee, we don't see any medieval art treasures listed on his inheritance, his estate tax return. Let's go down to Texas and interview that lawyer. They go down to Texas, they go into the lawyer's office. You know, the lawyers down there, they wear those little ties with the little strings hanging down, have those boots on, unlit cigar sitting in the ashtray. And the IRS says, hey, we looked at the federal estate tax return, and we don't see any medieval art treasures listed here. Lawyer leans back in his chair and he says, you boys from the IRS, you don't even look at your own statute. Section 2031 says you include on the estate tax return all items owned at death. He didn't own these items, he stole them. Well, says the IRS, you are not looking at this correctly. You have to, we don't bother here at the IRS with little things like title, and they do this with drug cases also. If you have the attributes of ownership, you are treated as the owner of that property. So you are treated as the owner. So, says the lawyer, this property is in the stolen property. It's worth pennies on the dollar. So the marketplace is the stolen marketplace. It's insignificant. No, says the IRS. Here at the IRS, we don't call that the stolen marketplace. We refer to that as retail, discrete retail market. And in the discrete retail market, this property could be bought and sold. And finally, the IRS says, the lawyer says, look, this is a debt. Even if you value it at the highest possible price, the property is owed back to the church in Quinlanburg. So it's a debt. But under the law of Texas, you have to file your list of debts within a certain period of time, and otherwise you will not be able to take a deduction. I mention that because it's one of the few instances in my entire career that I agreed with the IRS. So they were able to confiscate that property and give it back to the church in Quinlanburg. But that's not the only thing, the only reason why there is, there should be some volume on this. Don't you love the Eagles? I mean, I can remember just listening, lying on the couch and listening to the Eagles. I mean, I'm a tax lawyer. What do I know about birds or the Bird Migratory Act? But I represented Ileana Sonnabend, and she died owning this great Rauschenberg painting called Canyon, a really crucial work of modern art. And I looked up and we found out that if there's two federal statutes that say the Fish and Wildlife, what they call the Migratory Bird Act, and the Bald and Golden Eagle Act. So I was able to learn all about different kinds of eagles. But I knew that it was a criminal offense and a civil offense to sell anything with the eagle in it. And Robert Rauschenberg had the carcass of the eagle stuck into this painting, this combine painting called Canyon. So first I had Christie's value it, and they said no sale value, because it was a crime to sell it, to barter it, to possess it, to give it. In fact, the Fish and Wildlife people could technically seize it, the entire painting, a seminal work of modern art. When the IRS came in to audit the estate, they didn't like that. So they instead initially sent me a valuation valuing it at $15 million, which was the highest price sold at auction for a Rauschenberg. I said, listen guys, we have no market for this. We cannot sell this painting. And if you put a $15 million value on it, we're going to have to use $7.5 million of tax. When I disagreed with them, they sent me a final valuation and valued the painting at $65 million, which was very annoying to my clients, particularly since they have to pay $30 million of tax and $20 million of penalties, and if they sold the painting to get the money to pay the tax, they would go to jail. I tried to explain to the IRS, this doesn't make a lot of sense. And in celebration of this conference, I'm pleased to announce that last week, the IRS gave up entirely. And we successfully valued Canyon at 0, and the heirs of Ileana Sonnabend then donated the Rauschenberg to the Museum of Modern Art, where it will be on pretty much permanent display. It's true that they do not get an income tax deduction for what they donated. That was the negotiated settlement proposal. But here now we have a great work of modern art on public display where it will be for generations to come, and the IRS received no money. What does this have to do with anything? So, not only do I love the Eagles, but I love Bob Dylan. And when I read this one case, it reminded me, because Bob Dylan said, if you hear the words of Rainy Day Woman when he says, they'll stone you when they put you in your grave. So it reminds me of a case out of California, very important valuation case, particularly when we're dealing with gifts of art to our children to take advantage of that $5 million exclusion, the Stone case. And in the Stone case, we had first, we're going to do it quickly, first the husband died and the wife was surviving, and because it's California, it was community property. The children owned half the art, a very valuable collection of Impressionist art. The surviving spouse had this art, and the lawyers had to hire an appraiser to value the remaining 50% interest in the art. So they went out and hired a business appraiser, very prominent, very excellent company. But I don't think they understood the art world. What they said was, we're going to take a deduction of 44%. Now think about it for a second. They came up and said, because you only own the remaining 50%, we're going to deduct 44% of the value, so that it would open the avenue for everyone to give away part of their art, and then they only have a fractional interest left, and then they could take this huge deduction. Remember when we used to give away fractional interest to charity, it was 100%. It was the full value times the percentage. No discount for minority interest. The argument went a few times before the judge in California, and what they said was that really people will not sell their undivided interest. There's no real market for a fractional interest in art, and nobody is going to give up an interest in art. If two dealers buy a painting together and they get into an argument, possibly they could bring a partition action. And to bring a partition action, the court said it would be about 5% of the value that would reduce the value of the art. And eventually, the court came back and said, okay, we'll allow a 5% discount, but we're not allowing a 44% discount. So I hear all these arguments all the time about giving away a fractional interest, and for the most part, that is certainly not going to work, because the hypothetical willing buyer and the hypothetical willing seller would not buy a fractional interest in a work of art at a 44% discount. But that brings us finally to the one other case called the Elkins case, which comes out of the state of Texas. And this case was argued in January, and we are waiting for a decision. It's again this mythical plan of lawyers coming up with the most elaborate schemes involving family limited partnerships, trusts, all sorts of agreements. Again, we have a father dying. Actually, his wife died first. Then the father died. The children inherited and had part of the art. The father, during his lifetime, entered into a joint ownership agreement whereby the children and the father shared possession of the art. But of course, the father had the art all the time. They also had a rental agreement. The children rented back their percentage interest in the art to their father. But under the agreement, they didn't fill in the amount of the rent. So the rental agreement, there's always people trying to make gifts of art to their children, then renting it back. So I'm here to tell you that doesn't work. There's no real market for rental value of art. The other thing that was fascinating in this particular case was that the IRS allowed a 40% discount on two closely held corporations. They allowed a 40% discount on a piece of real estate, and they allowed a 40% discount on a racehorse. But when it came to the art, they allowed no discount. So at least in the state of Texas, it's better to be a horse than own a work of art. So what are lawyers supposed to do to people, tell people? Most lawyers want to be pleasing to their clients. They want to be creative. They want to develop these elaborate schemes where trusts overlap trusts and limited family partnerships, all aimed at reducing the value for gift tax purposes. But often, the best advice is to say no. That art is not necessarily the best thing to do to use as gifts for the $5 million exclusion, because you're not using the whole exclusion. You're locking in the long-term capital gains rate. So if you bought a Richard Prince for $100,000 and it's worth $2 million, and you give it to your children, you use up $2 million of your gift exclusion, but the children are locked into the capital gains tax at 28% plus the state and city, so it could be as much as 40% on if they ever go and sell it. And most of the time, the children, they don't want the parents' art. They hold it for a little while and then they want to sell it. So you're wasting 30 to 40% of your $5 million exclusion. So I always take the advice of my friend Caesar. No! And I've learned to say no to people. And when sometimes saying no to people is actually the very best advice that a lawyer could give, even though we lawyers bill by the hour, and saying no may only take a couple of minutes, that is very, very valuable advice, because looking at it long term, you're always going to wind up with something with trouble. So we know you can't give it and rent it back. That's a no. You can't give it and then keep it on your walls under Section 2036. That's a retained life use. That's also a no. If you are going to give it a work of art, give something that has not really appreciated in value, and make sure you deliver it, and make sure you change the insurance so that the children are clearly seen as the owner of it. Now, the other thing that we want to avoid clearly, I'm a child of the 60s. So. Roy Lichtenstein, I don't think he was thinking about tax penalties when he painted this. but we have all new penalties now on the art appraisers, on taxpayers, on the lawyers who sign the return. It really has a chilling effect on valuation, because when someone dies, they want the value low. When someone gives art to charity for a deduction, they want the value high. So the IRS has new rules, new penalties. If you overvalue it, you're going to be subject to a very high penalty. If you undervalue it, you're going to be subject to a very high penalty. You want to avoid at all costs those, so you want to hire the correct and proper appraiser. If you're gifting to your children, make sure they prepare the appraisal correctly and have a qualified appraisal done, just like it was given if you were donating it to charity, and make sure that appraiser is an expert in that particular field. You don't want an old master appraiser appraising a work of contemporary art.
Folks, just know, and you probably got a little of it, that the art world is a jungle out there. And if you're interested in finding your way through the jungle, I can tell you that our book is really a machete with brains that can help you to the clearing. Thank you.
Thank you all very much.